Hi, my name is Jeff Farnsworth, President and CEO of Steward Property Services. Right now we're going to guide you through the board orientation for new members and incumbents. We hope this answers whatever questions you may have about being on the board of directors, and please reach out to us if you have more questions. Steward Property Services is a full-service management and consulting firm located in Petaluma, California. We currently service residential common interest developments, commercial business associations, and provide bookkeeping and financial services. We were founded in 1991 by Mrs. Helen Laurier and are now owned by myself and my wife, Jennifer Farnsworth. One quick legal disclaimer before we begin. Steward Property Services Incorporated, a California corporation, otherwise known as SPS, provides management services for homeowners associations and common interest developments. SPS is qualified to do business in California with its principal office in Sonoma County. SPS does not provide legal advice, products, or services, and is not qualified to offer legal advice, products, or services. SPS does not provide financial investment or other advice. Individuals should consult appropriate professionals when making legal, financial, and investment decisions. This presentation is being provided for informational or educational purposes only and does not take into account the objectives or situation of any client or prospective clients. The information is not intended as legal, financial, or investment advice and is not a recommendation about how to manage your homeowners associations, common interest developments, or investments. Please consult with your legal advisors regarding your personal circumstances. In providing this information, neither SPS nor any of its affiliates or professionals is acting as your fiduciary. Let's start with the basics. Officer positions. All board members are directors, elected by the membership, through acclamation, or to fulfill a vacancy. Officers are then chosen by the board through a discussion and a vote. Consult your bylaws for specifics on election rules and voting processes. Typically, you'll have a president, vice president, secretary, treasurer, and a director. If there are only 3 positions, it may be a president, secretary, and a treasurer, or one seat may be occupied by 2 officer positions. The president typically presides over all meetings of the board or membership. They orchestrate and lead board meetings. They interface with management and committees. They sign contracts and other written instruments, and they verify that board direction has been fulfilled. The vice president serves in the absence of the president, assists with running meetings, may be assigned other responsibilities as needed, and is typically the co-signer on association accounts. The position of secretary is responsible for the association records. They review and sign minutes of all board and member meetings. They verify proper notice of meeting was provided and are co-signer on association accounts. The treasurer will review the financial reports on a monthly basis. They will also review the reserve study in line with available funds. The treasurer is responsible for integrity of accounts and is also a co-signer on association accounts. If there are more directors than there are officer positions, you may assign someone as a director at large. This may be assigned duties by the president. This position has voting power and may or may not be a co-signer on association accounts. Again, consult your bylaws for specifics on election rules and voting processes. Be sure to remember that your community is also a multi-million-dollar real estate corporation. It's easy to lose sight of this when you're dealing with rule enforcement and neighbor-to-neighbor issues. Your first priority should be utilizing the experts and concentrating on proactive maintenance of the common areas. A board member should consider where and how your efforts are best spent. Always consider quality of work over price. And always remember you're using everyone's money. Sometimes the best solution for the corporation may be the toughest for its members. Let's talk about fiduciary duty. Because board members are entrusted with the money and property of the association, they are held to a higher standard and are deemed fiduciaries. Fiduciary duty is the duty to act for someone else's benefit, while subordinating one's personal interest to that of the other person. This means the decisions are selfless and made in good faith for the benefit of the association. Another important part of being a fiduciary is to remember the business judgment rule. What that means is to perform the duties of your office in good faith and in the best interest of the corporation or the members as a whole. You must use reasonable inquiry, which means asking your experts, asking questions, making sure that you understand all the information presented before making a decision. As an unpaid volunteer for your association, many directors ask me about protection. Why do we use the business judgment rule? Why do we have to adhere to duty of care, duty of loyalty, and duty of obedience? These are the practices of a fiduciary that will protect you when your decisions are questioned. Duty of care means decisions made with reasonable care to avoid harm and relying on your experts. Duty of loyalty means to act in the best interests of the association and avoid conflicts of interest. Duty of obedience means that you too, as a director, must follow the rules and policies of the association. You are setting the example. In addition to good business practices, the board is also protected from liability by their D&O insurance, or directors and officers insurance, which protects volunteers from personal liability for decisions they make while on the board. You also have statutory indemnity. The Davis-Sterling Act protects volunteers from personal liability provided they meet certain criteria, and the governing documents of your association. Protection from liability is expressed in the CC&Rs and bylaws for the association. Provided you are making your decisions in the best interests of the association and community as a whole, and you are following good business practices, acting in good faith, performing duty of loyalty, performing duty of obedience, you are also covered in these areas by these protections. Now let's talk about board meetings. Board meetings are often confused with member meetings. Board meetings are scheduled at the convenience of the board. This could be during the day or during the evening, whatever is easiest for the majority of board members to adhere to. This is for conducting the business of the association. Every board meeting has to have a homeowner forum. This is a section where the homeowners may bring up issues that they have been thinking about or need to communicate. Every board meeting is required to have a homeowner forum where homeowners may voice concerns, questions, or opinions for the board to consider. A challenge that comes up with the homeowner forum is that by law, the board may not discuss anything that's not already on the agenda. So if a homeowner brings up a new topic, this must be tabled and placed on the agenda for a future meeting. Because the board meeting is a business meeting, professionalism should be expressed by every member. Someone should be taking meeting minutes that are recording the motions and decisions made at the meeting. Robert's Rules is not required by law. However, it is a great practice in order to provide clear direction on what decisions have been made. Fiduciary boundaries. As a professional fiduciary, boards should remain professional at all times. They should also be willing to listen to other points of view and have a positive deliberation. Boards should be consistent with their enforcement and be informed about association issues. They should seek professional guidance when appropriate and establish clear guidelines and policies. It is also extremely important that the board communicates with a unified voice. Communicating with a unified voice means that the board speaks with one voice. All decisions after a vote are final. Communication can be relayed by the manager in order to keep this voice consistent. That way, the manager is speaking for the board, and individual board members do not have to put themselves at risk by speaking outside of a meeting. To further protect your decisions as a board, individual directors should not discuss board business outside of a meeting. You should not discount the advice of your experts. Take it into consideration, but do not discount it. Failure to disclose a personal or financial relationship with a vendor can result in a conflict of interest. Boards should not react emotionally to a controversial issue. Keep a level head and make decisions based on facts. Do not disclose private information with owners. This should be discussed in executive session for protection of the association and the board members as a whole. Boards should not breach confidentiality of executive session decisions. Another form of protection for directors is delegation. Some duties of the board may be delegated to the manager. This takes risk and responsibility away from the board and places it on the manager facilitating the board's direction. During a board meeting, the board votes. The majority wins, and if it's a tie, the motion fails. The manager does not have a vote. The manager is there to take the minutes of the meeting and facilitate the board's direction. The board is ultimately responsible for all direction they give the manager and all decisions made. The manager interfaces with the members and the vendors on behalf of the board. Delegating to the manager and having them facilitate your direction, interface with the members, interface with the vendors, protects the unified voice of the board. It protects the board members and the directors by allowing the manager to carry your message. Other benefits of delegating to a professional management company are the resources and relationships that they can acquire over their tenure of service. Their managers are provided with ongoing education and certifications in the specialties of their field. They can leverage technology to provide services and processes that can increase efficiency. Increased accountability and a sense of neutrality, safe harbor, and distance from those members who may also be your neighbors. Communicating within your association can be frustrating given the processes offered by law. The best practice is to send communication to the manager in writing. This way the manager can research any questions and provide the board with information that may assist you in making a decision. Management then will execute the request within the limitations of the management agreement, or they will compile the information for discussion at the next board meeting. Email deliberation versus the Open Meeting Act. Board members can get into tricky situations by emailing each other in between meetings. When a board is making a decision or deliberating on an issue via email, it defeats the spirit of the Open Meeting Act and does not provide that open deliberation to the members of the association. When a singular director speaks outside of a meeting, the protections discussed earlier may be void. Directors must follow due process and have patience when enforcing the rules. Okay, let's summarize. The key players and partners that make up your association are the board of directors, the members, your professional management team, and your vendors. Your board of directors are the unpaid volunteers elected by the members to run the corporation. The members of the association automatically become members when they buy a unit within the association. Your professional management team will provide a resource and guidance to help you navigate the ever-changing rules and regulations here in California. Your vendors can be the eyes and ears and should be licensed and insured. They can provide a historical knowledge of the association that may be critical in making decisions. When we talk about running a multi-million-dollar real estate corporation, there is nothing more important than maintaining the financial health of the association. The critical components to determine the financial health of the association are the association budget and reserve study. The budget will discuss your operating expenses and should be reviewed by the board on a monthly, quarterly, or annual basis. Your expenses necessary to operate the association can be utilities, insurance, management and administration fees, common area maintenance fees, backflow devices, landscaping, and legal fees. The association reserve study should be reviewed and adjusted annually by the board. This is initially created by the Department of Real Estate and may not reflect the current expenses of the association. The reserve study will show you the estimated life of components and must be assessed annually. You should consider adding infrastructure components that may require maintenance outside of 30 years. A couple examples of this could be your entire irrigation infrastructure. It might be the plumbing inside of your condominium walls. Talk to your reserve analyst and your trusted contractors to determine which components may be important to your association. Knowledge is key. Some of the resources for board members are ECHO, the Executive Council of Homeowners Incorporated, davissterling.com, CACM, CAI, IREM, and don't forget about your management company. Steward Property Services is here to help. Thank you for watching this presentation. If you have further questions, please feel free to use the contact information on this slide. Thank you for watching. It's an honor to service your community.